So, good evening. Is everyone joining us for this beautiful evening and a new conference call format? Welcome everybody to what normally would you be hearing NARSOL in action, but it's going to be Can They Do That tonight? So welcome everybody and thank you for joining us. And we have two outstanding guests. We have attorneys that were on the last call, Lea Bickerton and Katherine Strohl. Ms. Bickerton, welcome.
I'm here. Thank you.
So bear with us. We're working through some technical issues with this new platform we're using. Our producer's trying to get rid of the echo as I'm speaking, but we're glad to have you tonight. And we're going to move through our questions on this program. It was not intended to be Pennsylvania, but there's been news out of Pennsylvania that's going to bear some relevance to our discussion tonight. There's a lot of folks wants to know, so we're going to spend at least the first probably half hour talking about what's going on, and that's going to be primarily Ms. Bickerton. And Katherine, you're free to jump in if you have any questions and want to help me kick this around. This is a brand new format, so we will be inventing it as we go. It won't be quite as rigid as we have developed with the NARSOL and action calls. So we're going to start by saying, Ms. Thank you for joining us again on such short notice. And we want to talk about the action as people have joined this call from Pennsylvania. There was a decision recently in 2017 that declared the SORNA to be unconstitutional, which was enacted in 2012. And three prior versions of Megan's Law were in effect that were either repealed or canceled or various things. So this was actually, I think, the fourth version of Megan's Law, or sex offender registration, I should say. And then the Supreme Court of Pennsylvania said that it was unconstitutional. And now we've got a new statute that was enacted by the Pennsylvania Assembly. So it was intended to address the court's concerns. So I'm going to ask you an easy question at first. Did it do that? Is this, I believe it's House Bill 631, Act 10. Do I have that right?
That is correct. And the answer to your question is that somewhat. It dealt with some of the issues. So as far as SORNA is concerned, the Pennsylvania Supreme Court didn't conclude that the whole thing was unconstitutional. What they determined was that it was punitive and couldn't apply to people whose offenses and convictions happened before December 20th of 2012. So what this new, it's called Act 10, what it's designed to do is to make minor tweaks to SORNA in order to make it clear that it's only applicable to people whose offenses took place before December 20th, 2012. And then it created a whole new subchapter in the sex offender registry statutes to provide for people whose registration obligations were triggered before December 20th, 2012. They call it subchapter I. But basically what it does is, like I said, it applies to people whose offenses were before December 20th of 2012.
So anybody whose offenses occurred after December 20, 2012, they were not impacted by the decision, nor they're not impacted by this Act 10.
There is an argument to, as much as I hate to give such a lawyer answer, kind of. For people who were determined to be sexually violent predators, the way that Muniz was interpreted by the Commonwealth v. Butler Court may have an effect on the SORNA people, on individuals who are sexually violent predators under SORNA. But for regular registrants, Muniz doesn't really offer a lot in the way of relief because it's not really considered to be an ex post facto law for them.
So there would, if those folks were to want to challenge if those folks were to want to challenge what could be done to them, they would have to initiate their own separate challenge for the people whose offenses occurred after December 20th, 2012. We've got
Yes,
people
they
that
would.
write and asking, so what about us? So what about us? That's what your answer is to them.
Yes, that it would have to be a separate type of suit, because even though, people who are on the same page as we are, that we believe that sex offender registries are ineffective, that they are just too much, it doesn't tend to accomplish what the government says that it's supposed to. If that's your position. Unfortunately, Munis doesn't really offer relief. You would have to take a different tack in order to try to challenge that.
So, well, in order to try to expedite Teresa, thank you for preparing questions. I went through your questions and I did cull down trying to, in the interest of time. So we're gonna go through the questions that I thought were probably going to be the most asked of the list. So we've heard from a number of individuals that the Pennsylvania State Police is no longer sending out notifications to register, which they do in some states, reminding people. Can you shed any light in terms of the practical implications of those on the registry and how notification to register is addressed in Act 10?
Okay, so for people who have a continuing registration obligation, the state police will keep on sending out those notifications. And I think that the most important thing that I want to enforce tonight is that if you haven't received a letter from the state police telling you that you don't have to register anymore, then you need to keep on going in until you get that letter from the state police, because according to the law, the failure to get notice is not sufficient to remove your obligation. So even if you don't get a letter, if you don't show up to register, they will try to charge you with failure to comply with those registration requirements. So as far as the notifications that aren't necessarily going out, I think that right now the biggest effect is that it's confusing people. But I think that people need to understand, until you get a letter taking you off the registry, you still have to go in and comply, because Act 10 continues that notification obligation that the state police has. But just keep in mind the fact that even under Act 10, which is, the continued registration of sexual offenders provisions, you're still punished if you don't go in to register, even if the state police forgets to remind you.
So in the states like mine where they don't send out anything, even though the statute says they're required to, if they didn't get this notice, you would not urge that as a defense to even attempt that to keep your own schedule and go in on the schedule that you would have had to go in regardless of whether you get a notice. Now, it brings an interesting twist to the question, because the people who were enhanced by the 2012 changes, if those are no longer enforceable, those people went from an annual to 4 times a year, so they would be getting 4 notices a year under the 2012 version that can't be enforced. So how would they know when their next due date is?
What they should do is to call in to the state police and ask them when their report date is. If they go on to state police website, they can see when their initial registration date was, and they can kind of extrapolate from that. Also, when they first registered in Pennsylvania, the state police actually lets you know when your initial date is, and they let you know how often you have to go in. And for people whose registrations were changed back in 2012, they received notice that they would have to go in 2 times a year or 4 times a year instead of once a year. So when in doubt, contact the state police, dig up that information, or just show up, and the troopers at the barracks will let you know when your actual time to go in will be. But bottom line is, no matter what you do, whether you're going to call into the state police, whether you're going to dig up your old paperwork, or whether you just show up at the barracks, show up until you get that letter taking you off the registry.
So I'm going to try to drill just a little deeper. So they were once a year in 2000 prior to 2012, and then they became 4 times a year in 2012 on December 20th. But now theoretically they should be going back to once a year if they haven't completed their 10-year obligation. So if they've already gone in January, and that would be 1 time a year, would they go back in 3 months later? When would they decide they need to go in again if they don't receive a notice? That's what I'm trying to clarify, and hopefully.
What they should do is go with the last thing they were told. If you are on a 4-time schedule, as much as it may be terrible to keep on going in every 3 months until you get that letter, in my opinion, it's better to go through the hassle of going in more times than you need to than to try to argue bail because they picked you up on failure to comply with registration requirements.
So, all right. How long do you think it's going to take the PSP? This is merely speculation of Pennsylvania State Police to notify those who will be removed, those who were in the 10-year track, got enhanced, and now they're back in the 10-year track. Is there any way to even guess how long it's going to take them to? Because everybody that thinks that their 10 years is done, they want to be off yesterday, and I can't say I blame them.
User entered your channel.
Right, and it's a process that the state police is estimating, and this is before Act 10 was enacted. They estimated that it could take a year to a year and a half to get that all completed. What I'm advising that people do is that if they don't have any type of notification in 6 months, that's when you'll want to call in again to the state police to find out what their plan is as far as their particular registration, or at that point, it may be wise to consult with an attorney.
So, will those who have not yet finished their original 10-year period and whose registration periods were enhanced be notified of the change? And I think we've covered that. That was the plan prior to Act 10, but has there been any change in that plan to notify people? Did Act 10 nullify what we had expected on the last call, that there was going to be notices that they would be returning to their 10 years, or they'd be notified that they're done?
Individuals should be given notification to state police. As far as people who are currently on probation, I've heard some feedback from some people where they're already getting notification about what Act 10 can do to them. So it's starting to filter through, so they should receive some type of notification from state police. I would say that if for people who are currently registering, if they've heard nothing from the state police at all, like nothing about the fact that they're being reviewed or anything, I'd say to give it about 3 months, so around May. If they haven't received anything from the state police at all, then they should call in to find out what the status is and what the plan is.
So there's a lot of phone calls going to be going to the Pennsylvania State Police to try to sort this out. This is one we tried to answer last time, and I don't think we have an answer yet. How does Act 10 impact those that were convicted in states or other jurisdictions?
It would be relatively similar to basically the layout that they have for people who are pre-SORNA or post-SORNA. So if you're someone who has an out-of-state or foreign federal conviction and they had a registration period that was 10 years or December 20th, 2012, then they should get the same type of relief. Now, if you're someone who had a conviction that was after that particular date, then again, you're not really going to be affected by it because MUNIS doesn't really affect you. Now, one thing to be aware of is that there are some individuals who previously 10-year registrants for SORNA, but after the state police took another look at it, they determined that, the initial classification was correct, and they always should have been lifetime registrants. So one of the recommendations that I'm making for people who have an out-of-state, federal, or foreign conviction is to call the state police and find out what they're doing, or to get in touch with a knowledgeable attorney to try to figure out what may happen here and to pretty much establish a game plan for how to proceed if they aren't taken back to where they were before SORNA was enacted.
So once the Pennsylvania police do complete these reviews, then we're only guessing how long it'll take, and people that believe they should be off or not off, what should they do to rectify their situation?
Well, the first thing that they should do is to get in touch with the state police and ask them what's going on, because it's possible that there was a mistake made. It's possible that they were missed, and it's also possible that the state police made a determination that was just wrong. And the first step is to get that information. Some people prefer to contact an attorney to have them get in touch with the state police first, but the first thing that I recommend is, contact the state police yourself, find out what they have to say about why it is exactly that your registration period has not changed. Now, in an ideal world, you'll get that type of information in writing, But in my experience, for individuals who call in to find out why they weren't reclassified, as far as past situations where the state police has had to reclassify individuals because of a change in the law, they generally don't send anything in writing if you call in. And when you call in, they'll tell you why they did what they did, and then they'll leave it to you to contact an attorney or to attempt to change things through your own lawsuit. So step one, contact the state police. If you are unhappy with what the state police has to say, consult with an attorney to have them review your info, and then the attorney can either file a memo or a letter with the state police or file a lawsuit to get a court to compel them to do the appropriate thing.
So I'm going to bring Teresa in here shortly to ask you the question about the Butler decision, but I'm going to ask you, is there any specific information in terms of what the registry projects to the world? Is there any information that will no longer be included on the public website as a result of the decision? And that's a two-part question, because if the decision itself said yes, did Act 10 nullify that? Is the website going to contain less information than what it did going forward?
So when you take what's included on the Pennsylvania State Police's Sex Offender Registry website, and you line that up with what SORNA provided and what Megan's Law 3 required, a lot of it's going to revert back to what it was in Megan's Law 3, and the differences are very slight. And by very slight, I mean, one is that your employer's address will not be on the website anymore. It'll just be the county and city of the employer. The other change is that under Megan's Law 3, there was an annual photo, whereas under SORNA, it was a current photograph. So you were seeing more frequent pictures being taken. So as far as the information that's going to be reported and included on the public website, the changes are, I would call it, minuscule.
Well, the employer is a significant one, because there are people who harass employers for hiring folks on the registry, so that is a very significant accomplishment. We wish we could get it off of all websites. Well, of course, we wish we could get everything off, but we wish we could get that off so that people's employers don't get badgered for hiring people on the registry. So they'll go back to being no longer disclosed their employment, and that would be for the people who benefit from this decision. But people convicted afterwards will still have theirs listed. Is that correct?
I'm sorry, I'm getting a little bit of an echo.
Yeah, we've got the big echo back. So hoping our technical people can figure this out.
Yeah, me too.
So I guess I'll do my best to answer based upon what I think you said. But as far as the information that the individuals have to provide, how much of it has changed, it's really going to be the same. It's going to be the information about tattoos, license plate, vehicle information, address information, physical description, all of that will still be maintained on the site.
But the employer, for the people after 2012, their offenses, theirs will still be, I'm assuming, will still be displayed. They're only going to suppress that because of this decision. So
that information appears to be the same.
So, and then there was another question here about the notion of toll time, and I didn't understand that, but you did, because you said you would answer it. So,
yes.
Is there any provision in the Pennsylvania Sex Offender Registry statute that tolls the time towards your 10 years? And obviously there is, or we wouldn't have the question here.
Okay, yes. So ultimately the tolled time refers to time that you're not getting credit for the time that you're on the registry. And in Pennsylvania, you are not given credit for any time that you were spent incarcerated. And that has actually been the case since at least 2001. It was there in Megan's Law 2, Megan's Law 3, SORNA, and they've basically maintained that. So if you're looking at how much time is going to be credited towards the time that you have to serve on the registry, if you let's say you spent 5 years in jail, you're going to end up being on the registry for a total of 15 years, because those 5 years that it's showing that you are incarcerated doesn't count towards the sex offender registry credited time. So the toll time means that they stop the clock anytime that you're incarcerated. And one of the things that I think is kind of unfair is that it doesn't make a distinction between whether it's for being recommitted for a parole or probation violation or getting new charges. So what people have to be prepared for and to be prepared to fight is that even if you are rearrested on unrelated charges, the language is so vague that it appears that you may not receive credit for the time that you're incarcerated, even on unrelated charges.
So the 10-year term could be considerably longer. And I have this discussion with people because they'll say, well, I got convicted and I served 7 years in prison, and that should count toward my registry. And I said, well, I don't see how you can make that argument because you weren't complying with you weren't reporting to anybody, you weren't doing anything. Well, they put my name on the list. And I said, well, they did do that, but that was only one step of it. Now, in our state, your initial registry doesn't happen until you get out of incarceration within so many days of release. But we don't have a provision for tolling of time. But I think administratively, the department has tried to tell people we don't give you credit for that time, but it's not in our statute. So it is actually the Pennsylvania statutory scheme that time is tolled, but yet it's not clear of how they count the toll time.
It's basically any type of time that you are incarcerated is supposed to be excluded. Now, again, I personally disagree with it because if the entire notion here is that the time on the registry is to keep the community safe, to know your whereabouts, in my opinion, if they know that you're in jail, that should be credited. And I think that that's a potential argument to show how the sex offender registry is actually punishment, not necessarily about community safety, but that's an argument for a lawsuit another day, I guess.
So, Teresa, you are unmuted and you had that question about I think I unmuted you. Teresa, are you here?
Yeah, I'm here. Can you hear me?
Okay, so yes, we can hear you really loud and clear. So the question that I didn't understand about Butler, we've got a few more minutes, so we can do that and a couple more questions that you would like to throw in here.
Okay. So, hi, Lea, and thanks again for helping us out here. So the Butler decision indicated that the current process for determining SDP status is unconstitutional and indicated that determination must be made beyond a reasonable doubt. The language in Act 10 seems to retain the old standard of clear and convincing evidence. So it would appear that Act 10 doesn't adequately address the Butler decision. What are your thoughts regarding this?
I would argue that it doesn't adequately address the Butler decision because it doesn't provide for a finder of fact making that determination. Person who suffers from mental abnormality beyond a reasonable doubt. So that particular part of it, I think that the revised law completely fails. But what I think, and this is all speculation on my part, I think that what they believe is that they fixed it by taking out the retroactive provisions of that, where the entire going back and applying this to people who were convicted and had offense dates from before December 20th, 2012. I think that perhaps that's what they thought would be enough to fix it, or perhaps they were thinking that Butler may be overturned, because I believe that a petition for allowance of appeal was filed in the Butler case. So again, it's difficult to know why they didn't go farther in trying to remedy the constitutional issue that the SDP statutes present. But I think that it's going to be interesting to see what happens with the Butler case, whether the Pennsylvania Supreme Court takes that up, and whether individuals who are affected by Act 10 should file suit, basically following the conclusions that were made in Butler.
Okay. So I wasn't aware that they had appealed it. I thought they hadn't. So I'll need to do a little homework on that. So I have one more question, if that's okay.
Sure, we got a few minutes.
Okay, so we are along the same lines in terms of constitutional challenges. We're wondering what, in your opinion, anyway, as far as this new law is concerned, if you see any opportunities for additional constitutional challenges to Act 10, and if so, what are the challenges? Exactly, and what types of cases would make good test cases for these challenges?
I do think that a good part of it should be able to be challenged, because one of the things that the Pennsylvania Supreme Court was looking at in the Muniz decision was the fact that when you see the information that's put on the internet, when you're making people show up in person, that it's very similar to what people have to do when they're on parole, probation, and other types of supervision. So when you look at what Act 10 has provided, the information that has to go in, it really does, it still looks punitive. I think that the only change is that as far as the retroactively increasing the duration of the registration requirements, Act 10 fixes that particular part of it. But when you're looking at the actual punitive aspects that the Pennsylvania Supreme Court identified, I think that it's fundamentally problematic. For individuals who were convicted and had offense dates under Megan's Law 1 and Megan's Law 2, there was no internet component there, and Act 10 still provides that particular aspect of it. So I think that that's where there was going to be a path for a suit, is the fact that you're still looking at these punitive measures, you're still looking at the issues of reputation. And one of the other issues that I find interesting is that with the provision that's permitting people to petition to be removed from the registry after 25 years, it's where I find that to be fundamentally problematic, is that under a prior law, people were able to do a petition to be removed after 20 years, but they added an additional 5 years on there. So I think that that's going to be a particular avenue for suit as well for individuals who are coming up on 20 years on the registry. And as far as the cases that are going to be appropriate, I think that just about anyone who has an offense date that was under Megan's Law 1 or Megan's Law 2, and they have that information on the internet, that's going to be a very, I'm not going to say a very strong suit, but that's certainly one that I would love to litigate. For individuals who have offense dates under Megan's Law 3, I still think they have solid arguments there as well, especially since Megan's Law 3 was determined to be unconstitutional. So the fact that they are now being compelled to register, even though the law that originally compelled them to register was deemed unconstitutional, and you still have those punitive aspects under Act 10, I think that that does make for a good avenue for relief as far as individuals who had offense dates under Megan's Law 3.
Very good. Well, that's all I have. I thank Larry for asking the rest of the questions, and thank you again.
My
So
pleasure.
thank you, Teresa. Thank you, Teresa. Katherine, did you have any questions before we move into Can They Do That? Hope we haven't lost her again. Well, clearly we have lost her for the moment. So did you have, Lea, did you have any other comments or things that you would like to say before we go to the new program?
Well, I think that one thing that I might want to cover briefly is the issue of this new 3-year probation tail that they have for individuals who are convicted of Tier 3 offenses and who are sentenced to incarceration.
What is that?
Because it's, I'd say that it's almost like Frankenstein's monster, but basically what the Pennsylvania legislature did is they determined that because a lot of people who have sex offenses are serving their maximum sentences of incarceration, that they feel that they need more supervision in. So in order to provide for that, they're making people who have, so let's say that a judge originally only wants to give someone a sentence of 5 to 10 years of incarceration. Starting after April 22nd of this year, they're going to have to put an additional 3 years of probation on the end of any sentence of incarceration that they have for someone who is convicted of a Tier 3 offense. So it's something that affects people going forward. It doesn't affect people whose offense dates came from before that particular time. And where I really find that to be, this particular part of it to be a little bit troubling, is the fact that they are actually permitted to increase the statutory maximum sentence, provide for this 3 years of probation. So in Pennsylvania, a first-degree felony is punishable by no more than 20 years of incarceration. With this little provision, with this sex offender mandatory probation tail, they can now end up with a sentence of 10 to 20 years of incarceration plus 3 years of probation. So if you have someone who happens to violate this new probation, they can actually end up doing more than the statutory maximum because of this new law.
We have that same issue here in our state where they are able to stack out more time than what the statutory maximum is by doing that. So that is very problematic. So, well, then I'm going to actually shift gears here, folks. We're going to begin recording this portion of the call.
The recording has started.
And we're going to go to what we had advertised as the new program, Can They Do That? And Can They Do That is intended to answer general questions about things that just really bug you that they're doing. And they means the system, whether it be law enforcement with your registry requirements, whether it be probation, parole officers, whatever it is, we're going to try to give you a general response. We won't be able to gather enough information about your specifics because it would devour the whole phone call. So what we're going to ask you to do is ask a question and then let the attorneys come back with questions rather than starting to tell a story, because the story may not be necessary for the question. So I'm going to give an example of some questions, but I'm also going to read a disclaimer. Keep in mind that responses provided on the program are merely intended to offer guidance and should not be construed as legal advice. We cannot cover the specifics of any individual's situation sufficiently to know what the most prudent course of action is. So NARSOL advises all participants to consult with an attorney in their jurisdiction to determine whether or not they may have a viable cause of action. So please don't get off of this phone call and say, Ms. Bickerton or Ms. Strohl said that I have a good case and I should file tomorrow and I should tell somebody, because this is not the purpose of the program. We're going to help guide you towards some solutions. But Ms. Bickerton, I would like to know, for a person on probation, I've seen a behavioral contract that says that they cannot have any relationships of a sexual nature with any adult without the approval of their probation officer or parole officer. So you can't have a boyfriend or you can't have a girlfriend without permission, having that person approved. Can they do that?
And I guess I should have that little caveat that, they can do just about anything, but whether they should and whether it's constitutional is really a completely different question. And with that particular situation, the first question that I would have is, what is the underlying offense? If it is something that has to do with domestic violence, that's where I could see that they could start to go in that direction. But, I think that overall, do I think that that particular type of provision is something that can pass constitutional muster, regardless of whether it's a DV conviction or not? No, I think that sounds fundamentally problematic. I could see potential issues as far as the right to engage in relationships with other people. That seems overly punitive, and it also seems to go after one of the rights that they consider to be part of the quote-unquote penumbras and emanations of the Constitution. One of those rights where you just know that it's there, but it's not necessarily explicitly there. One of the fundamental rights that we have is to be able to associate with other people, and to say that someone cannot have a relationship without approval is just, again, I don't see where that would be constitutional. If I had a client with a probation condition like that, I would certainly be challenging that.
Well, they hand this behavioral contract to people, and it's under a heavy hand that you're told these are your conditions, and there's just a litany of things. That's one of them. But it's not a negotiating session. They hand it to you. They say the judge sent you here. You've got 5 to 20 probation, and these are your conditions. What would a person do when they're handed that? Because what's going to inevitably happen is they're going to sign the thing, and then when they try to challenge it, the state's going to argue, well, they agreed to it.
And I think that there are two ways of addressing that. So for someone who in this situation and they're put, that quote unquote contract is put in front of them, what I would say is sign and indicate that you're doing it under protest. A lot of times putting under protest doesn't necessarily carry a lot of weight. I think that this is a situation where if you're looking to fight this later, at the very least, you're preserving it. Now, if you're someone where you've already signed off on this contract, I think that it's more of a document that's confirming how they dictated terms to you. But hey, let's go ahead and call it a contract. So if you're someone who's already signed one of these contracts, what I would do is I would still sue. Just because an agent of the government has had you sign something doesn't mean that it wasn't coercive. And when you're being told, hey, sign this or you're going to stay locked up, I would argue that that's kind of coercive. So I think that in a situation like that, you're going to want to consult with an attorney and see about filing a lawsuit about that, because I do think that there are some constitutional violations there and potential for a civil.
So, well, I'm going to go the different path of the registry home verification checks. In Pennsylvania, you have a system where it's done with the state police. That's the same situation in Virginia. Most of the states have this hybrid model where the sheriff, or even some combination of the sheriff and the local police register people, and so you have a sheriff who's mostly elected around the country who loves going with the cameras rolling. They roll in on these people's homes, and they'll even be in a combined law enforcement operation with U.S. Marshals and with whoever all they can muster. It'll be many agencies, multi-agency task force doing an offender residency verification. We're told on a regular basis that they demand and insist that they be allowed to enter people's homes, and these multi-agency task forces will have officers even from the probation parole office. So you may be rolling into people who are under supervision, then you're going to the next house that's not under supervision. What are people? Can they demand to go in people's homes that are not under supervision? And what happens if someone refuses?
So if you're not under supervision and they're attempting to enter your home and do a search without having a warrant, I think that that's a violation of the Fourth Amendment, because what the legislatures that impose these sex offender registration laws love to say is that it's not punitive, it's a civil thing. So if it's a civil thing, there is no implied consent where you're just letting law enforcement come into your home. It comes down to whether they have probable cause to do a search. And refusing to let law enforcement in to search your home just because you happen to be on the sex offender registry, I don't believe that given up that right by ending up with a conviction that puts you on the registry. Now, if you're on parole or probation, and they happen to have your PO with them, then your rights under the Fourth Amendment are limited because of that supervision. But if you're not under supervision, I think that there's a good, arguable Fourth Amendment claim there.
So would you tell people to stand firm and deny access, or specifically consult an attorney in their jurisdiction? Because this is really one of the most common call, and we have people that are distraught about it. Their families are there. They've got these. In some cases, they'll have several of the officers, and they'll have their hands on their holstered gun, and so you got a 9-year-old and a 7-year-old, and you got these people knocking loud at the door, and they're saying, "Let me in." And the child is saying, "Daddy, what's happening?" So it's very traumatic for people, and this is something that we deal with on a semi-regular basis of these residency verifications, and we'd like to figure out how to direct people to see if they can tone these things down without causing them more grief by having them being retaliated against.
Right, and that's where it's kind of difficult. Sometimes when you stand up for your constitutional rights, there are unfortunate and, in my opinion, unlawful consequences to that. So if you're in a situation where the police come to the door, you want to make sure that you have your hands up and plainly visible, no sudden movements. Stay calm, no name calling, no getting upset, and you will calmly ask if they have a warrant to do a search of the home. It's one thing for them to confirm that you are who you say you are and you're residing at that particular location. I think that one of the benefits of the sex offender registry is that law enforcement has your picture. So I don't believe they should have to wait for you to go grab ID to confirm that you are the registrant that they're looking for. But, in the event that they do ask you to go, you get that ID, you'll say, hey, I will go grab my identification, but Unfortunately, I do not feel comfortable consenting to a search of my home. And if you stay calm, you do want to ask to have an attorney present. You will want to, again, first thing, ask for that warrant, ask to see a copy of that in writing. But again, it's a difficult situation when you see law enforcement with a clear show of force, a lot of weapons, and if you feel that you kind of have to let them in, just make sure that you do not say that it's based upon consent. That, you want to make sure that you're saying that you do not consent to that search.
So,
but it's a tricky situation, because when you're dealing with, I know a lot of us have access to the internet, so we've seen the videos of what happens when individuals don't completely comply with law enforcement. So that's where, as an attorney, it's one thing for me to sit here and say, hey, ride your Fourth Amendment all the way down and, fight the good fight. But in practical situations, in reality, it's difficult to sit here and tell someone to assert their Fourth Amendment right when they're looking down the barrel of a gun.
So, well, folks, I'm going to actually clear the queue. I apologize. I'm going to try to get Ms. Strohl back, and I'm going to ask her to get, so everybody that's in the queue, I'll put you back in just a second, but I'm going to try to make sure we can get Ms. Strohl back in there. I think I see her now. She's there. Okay, I don't have to clear the queue. Okay, so we're going to go back to questions. I did these questions to give people an idea of you can actually ask a question without having to tell a story. And if either of the attorneys need more additional information, they will ask you. So we're going to take our maiden caller, and this call area code is originating from Florida. So 941, you're on. Can they do that? Go ahead.
We don't have a question at this time. We were trying to get online. Sorry.
Okay, sure thing. So, area code 312, ask your question. You're on. Can they do that?
Oh, Larry, it's me, Katherine.
So, well, then you can. All right. So then we'll keep moving here. So, area code 717. Go ahead with your question.
Yeah, I have a question, but I'm not sure if it's appropriate at this point, because I'm not sure if you folks are only entertaining questions exclusively with respect to the can they do that, or on the or concerning the first part of the show with respect to time
we can do the first part of the show if you have a question. Go ahead.
Okay, I'll simply say that this is concerning my son. It'll take me 10 seconds to explain the situation. Simply put, he had a sex offense in 2004. He had his conviction in 2007. At that point, he was assigned a lifetime registry requirement pursuant to a case by the name of AS versus PSP. He was reduced from lifetime to 15 years. And the point I'm trying to get to is I want to see if I am, in fact, correct in understanding that since 15 years was not a possible sentence, if you will, at the time of his offense and conviction, rather at that time I think it was only 10 years or lifetime, am I correct to understand that, in fact, he would now have to be reverted to the 10-year registry requirement rather than 15 years?
For individuals whose original registration obligation was 10 years, it should revert as long as that offense date was from before December 20th, 2012.
I'm sorry to interrupt. His original assignment was lifetime back in 2007.
But what it should have been was that 10-year term, but he ended up having it longer because of that, AS issue?
Correct.
Okay, then yes,
so
it should revert back to what it. Okay, so with that AS decision where it determined that if you have more than one offense, that you basically are subject to a lifetime registration. What the Supreme Court did by saying that that particular interpretation was invalid, it was like that never happened. So for all intents and purposes, that registration was 10 years from the beginning. It's a little bit of legal fiction.
So
it's basically what.
So it should then, we're believing at this point, be 10 years, given everything I described and everything you just described to me.
Going from what you're saying, that's what it sounds like to me.
In that case, Ms. Bickerton, and I greatly appreciate your time, this hinges on something you said earlier. With that being the case, he's now been on the registry for 11 years, and you said earlier if the person doesn't hear something official from the state police, I'll say soon, I think you said maybe it's good to contact them in May, a couple months from now.
Yes. Yes.
Okay. Thank you so tremendously much. Greatly appreciate it.
Thank you for being on the program. For those of you that are thinking you might want to ask a question, if you would press *6 on your phone, if you're listening on the live stream, you will have to actually get on an old-fashioned phone, I think. But I've got a few people in the queue, so we're gonna go to the next person that's in the queue. So I believe this call's from Michigan, 248. You're on. Almost said NARSOL in action. You're on. Can they do that?
Yes, I was referring to the earlier segment that we had with contacting the state police and going through that method of approaching them about being off the registry. Is it possible that would work in other states besides Pennsylvania?
I lost audio for a second there. I'm sorry. Can you repeat that?
Oh, yes. Is it possible that contacting the state police, like you've been asking them to do in Pennsylvania, is that a strategy that will work, say, in Michigan with the recent Snyder decision?
I have no knowledge of other state laws. I know how the Pennsylvania has the registration obligation here, so it's really difficult to say. My recommendation is to consult with an attorney in the area to find out who's responsible for maintaining the registry up there.
Okay, fair enough. Thank you.
You're welcome.
So we're going to take a call from Tijeras, New Mexico. You're on. Can they do that?
Yeah, my question is, I'm in the prison ministry, and I deal with people that are on the registry, sex offenders, totally. And I'm having problems with probation and parole because I'm a felon who is also a sex offender, and they have a policy that says that they cannot, a felon cannot have association with another felon. I've gone through the head of probation and parole. I've gone to the Secretary of Corrections, and their answer is that it's against policy. My question is, do you think, because I've heard of other people that have gotten dispensations, a waiver of to be able to have contact with people that are felons, even though they're a felon. And what I was wondering, do you think I could maybe get more pressure or something by going to legislators, or maybe see if I can get the policy changed, or maybe my state senator? Or what do you think?
I think that just about anything is possible, but as far as whether going with the particular climate that we have as far as politics are concerned, do I necessarily think that that's going to be the most successful route? Not necessarily. Is it something that's worth attempting if you're willing to do the work to make sure that you're presenting the best arguments possible for why such relationships could be encouraged or should be encouraged? I think that it's certainly something to look into. One of the things to consider is the fact that in certain areas, the rates of convictions, even for felony offenses, are very high. And you have situations where, because of overcriminalization, you have a lot of people who are felons. And if you have someone who isn't allowed to associate with felons, they're basically going to be living in a bubble. So if you raise arguments like that and present that to the legislature, that's where you may see some type of a change as far as the law is concerned. But, how much mileage you're going to be able to get out of that, I think that it's really going to depend on what jurisdiction you happen to live in.
Don, I muted you for a minute. I'm trying to figure out where we're getting the echo, but I'm going to try to undo you here as soon as we can figure this out. I'd like to expand on his question because he and I have talked about this extensively. I think that what his issue is I've looked at the policy, and the policy really doesn't say what they say. The prisons have turned his telephone number off where he can't receive calls, and his ministry is a 501c3. So his position is that it truly is a ministry, and he's not associated. So we believe they're actually defining an association to include something that really wasn't contemplated by the policy. An association, in my mind, is you get together and hang out with the person. Well, he's not getting together and hanging out with these people except for at a halfway house where they're under supervision, or possibly in a prison where they're under supervision, or on a monitored phone call. So his position is none of those things are relationships. But Don, I'm going to try to bring you back here and see if I clarified that, but we're getting a lot of feedback here. So Don, did I explain that?
Okay, can you hear me?
Yes. Did I explain that as the way you wanted it covered?
Yeah, to a point. That is happening with telephone calls. They won't have me have association, but now it's happening. They're telling the parolees at the Bible studies at the halfway house that they cannot come to our Bible studies because of association.
Well, yeah, I mentioned that. I mentioned the halfway house.
Yeah, and they're also doing it to other functions that we have that they're not able to come because of association.
Right, and I think that's where trying to raise those arguments, and I think that if they're barring people from attending Bible study, that sounds like an establishment clause argument, and it also sounds like it may be that particular. So, can you go to a lawmaker and to try to get the legislature to establish better laws so that it's not so broad and doesn't affect people in ways that are not really helping to promote, law-abiding behavior? That's one thing. It sounds like this particular regulation is a little bit too broad. So, is there a potential lawsuit there, especially if what they're trying to get at is Bible study? I think that would be a very interesting lawsuit because that is interfering with religious practice. I think that they might make the argument that the fact that the person is a convicted felon may outweigh whatever, religious right there may be as far as that particular association. But I think that, would it hurt to try to pursue legislation? Not at all. Do I think that it's something that should be litigated? I believe so.
So I think we've lost Don somehow there. Thank you, Don, for that. We're getting nearer the break at the top of the hour, so we can chew the fat here for a second. We're going to have a 5-minute break. You'll hear some commercials and music, and then we'll come back for another hour of Can They Do That? And hopefully we can figure out what some of the echo is, why it's originating and coming through. So Lea, as you're pointing out here, when you tell someone that they've got a cause of action, that doesn't necessarily translate out to finding someone who will initiate that cause of action for them, does it?
No, because you always have to find a willing attorney, and a lot of times for civil rights lawsuits, they're not necessarily inexpensive, and a lot of attorneys are going to look for something that will be able to maintain their ability to eat regularly. So finding a lawyer who's actually going to be able to do it, that can be a challenge, but there's
there are risks inherent with that, and we'll pick up that on the flip side. But folks, we'll be back for a full hour of your questions on the Can They Do That? And we look forward to hopefully we can have a better technical platform in place. And so you are now listening to Can They Do That? And this is.
Once a convicted person has done their time, they should be allowed the opportunity to rebuild and contribute to society again. It is simply wrong that a registered person must report to police and get booked over and over again, sometimes for life. There is no way to appeal or to be relieved of this burden. Why? Because it is not part of most sentences. Since registration is a civil regulation, lawmakers can change registration requirements for the worse at any time, and they do. This is punishment long after the fact. But groups like the National Association for Rational Sexual Offense Laws are taking these matters to court to prove registration is truly punishment. Any person, once he's done his time, should have the same ability to live peacefully, to raise a family, and to become a contributing member of society. NARSOL works hard to help our registered citizens do just that. Remember this: if we deny constitutional, civil, and human rights to any group of American citizens, that threatens the rights of all. Join us today at narsol.org. That's NARSOL.org.
Just like people believe that the single greatest threat to their children is stranger danger, when the absolute consensus of facts is that 90% of child sexual abuse cases happen within the family or someone who has access to the child through a priest or a coach or a teacher. Stranger danger is the least likely thing that's going to happen to your kid. Much more dangerous to let your child go to Boy Scouts or Girl Scouts than it is that they're going to be randomly picked up in a playground.
Hi, this is Brenda Jones, NARSOL Executive Director. If you're hearing this, you know just how important our work is to citizens across this country who struggle daily with the challenges of being on a public registry. You know what it means to wear that scarlet letter or to have a loved one wearing it. NARSOL is fighting for the rights of millions of registrants, their family members, and their children to live free of excessive, repressive laws that keep on punishing long after their sentences are over. We are filing lawsuits challenging restrictions, and our volunteers are fighting in state capitals, not only to prevent new bad laws, but also to introduce positive change. We need you to continue our work. Have you joined us yet? Made a contribution? Go to narsol.org today. That's NARSOL.org, and click on Join or Donate. Do it today before you forget. Become a part of NARSOL's fight for your rights.
Are you tired of hearing what feels like gloom and doom all the time? Tired of the message that there's no hope, that somehow life is over? Humans on the Registry, that's humans.narsol.org, has been launched with the goal of sharing some positive messages about registered persons. This project of the National Association for Rational Sexual Offense Laws seeks to bring a little light and hope and humanity to this difficult subject through short stories about registrants who are succeeding in spite of the obstacles in their paths. Are you a registered citizen who has a positive story to share? Have you found meaning, a better tomorrow, a loving family, built a new life? Come tell us about it at humans.narsol.org and show the world and other registered citizens that we all have reason to hope.
So welcome back, everyone, to our second and final hour of Can They Do That? So hopefully we've got some of our issues resolved. And Katherine, we've not heard much from you. Did you have anything you would want to add or expand upon on the answers of the previous questions before we take new fresh ones?
No, I don't. Larry, can you hear me?
We're hearing you great.
Are you able? Okay. Some of that time I was, I think, on mute. I think that I have to dial *6 to get into the queue to speak. But no, I think you did a great job, and I don't have anything I can sort of add to what she's already said.
Well, feel free to jump in here. This is a panel, so we want to get perspectives from all parts of the country. So we're going to go to North Carolina next. What's your question for Can They Do That? What are they doing in North Carolina?
Oh, yeah. Sorry, it's me. Yeah, this has to do, I'm on parole in North Carolina, and it's mandatory 5 years. And they're still banning people from social media on parole. And in light of Packingham, you would think there might be some leniency, at least in this state, since SCOTUS kind of shot down lawsuit. But anyways, basically, it's really hard to determine what you're supposed to avoid. I mean, obviously, the big ones like Twitter, Facebook, pretty easy. But what the statute was done in North Carolina, it was so vague to begin with, it's hard to know what to avoid besides just avoiding the internet altogether, which is pretty much impossible. So I'm just curious, I've kind of argued with my parole officer about this particular restriction. In my case, I didn't solicit online, but I did have an online charge. But, I didn't think it necessarily applied to me. But anyways, that's kind of my question. We can just ban you on social media like that.
So in view of Packingham, what's his option in North Carolina?
I mean, parolees do have less rights and or not as many rights as even registered sex offenders once they're off parole. So, I mean, it is within their power, I believe, to restrict and monitor internet activity. Now, an all-out ban on internet usage at all, I think would be problematic given a Sixth Circuit opinion in Doe v. Harris. But that opinion also did say monitoring and restricting of internet access is permissible. I don't know how Packingham would, or that Packingham would even apply to a parolee. Lea, do you have an opinion about that?
I think that it's going to come down to whether it is really related to the offense. And if it is, I think that it's going to be a tough row to hoe.
So I hope that helps, and let's just sharpen that a little bit, because we've got listeners out there that they say, well, the Supreme Court said you can't just have a blanket ban on social media. But I recall in the dicta, they did say they were more concerned that they found it particularly problematic for people who had paid their debt to society and who were off all obligations. But when you look at your quote, Katherine, that said parolees have less rights, can you illuminate that a little bit, because that's going to be really puzzling to people. They're out in the free world. Why do they have fewer rights?
It's just they haven't completely finished serving their sentence. Parole is part of the sentence, and just like prisoners have less rights, I think even than parolees have less rights than people who've completely finished serving all time under the sentence, which doesn't include, the registry and whatnot.
So what might be permissible for a parolee, or reverse around, what may be impermissible for a citizen may be completely permissible for someone who's paying their debt to society, from a constitutional perspective. I didn't
follow. Well, what would be permissible for a citizen could be people who are on parole don't have as many rights. So parole officers can, or the legislator can, to govern people on parole that limit certain rights that the rest of us enjoy. That makes sense.
Yeah, that's what I was trying to get at, is that I'll get emails after this program. People will say, well, if it's unconstitutional for them, it's unconstitutional for everyone. So I'm trying to drill into that. What may be unconstitutional that the Supreme Court said you just can't have a blanket ban for people who paid their debt to society. They didn't say you can't have severe restrictions on people who are in the process of paying their debt to society, because as you pointed out, if you're in prison, the restrictions would be significant. They'd be significantly greater. You wouldn't have any internet access whatsoever in prison, except for possibly if you're in a federal prison. I think they have some limited access, but a total ban on social media might be permissible depending on your offense. I think that's what I heard the answer being. It might be completely appropriate, or they can severely limit and monitor you while you're serving and paying your debt to society. Do I have that right?
In my opinion, yes.
Okay. So, all righty. Well, we will move on to. I think we've had this call from Florida before. So, did you have a question now for Can They Do That?
Yes, thank you for taking my call tonight. My question is, back in 1987, I was convicted of an alleged lewd and lascivious assault on a minor. I was sentenced to prison and probation, which I completed both in 2000. In 2006, SORNA comes along, and I get put on a registry, and I'm just, my question is that not a violation of my Fifth Amendment as far as being punished twice for the same crime?
And I would say that it really depends.
There's more of a problem with an ex post facto violation than,
correct.
You know, right. And I mean, yes, I would argue that that's, you know, adding more punishment. You're skipping more punishment than what existed at the time of the offense, and even when you finished your registry. So, I mean, I think that there would probably be a good ex post facto argument there.
Okay.
So
well, I mean, you have to find somebody who would make it for you, or you could make it yourself. If you look at the Adobe Snyder case, the Sixth Circuit case that's been talked about a lot, you know, that's like the big case that has said adding these amendments to SORA that impacts people who were on SORA prior to the amendment is a violation of the ex post facto clause because it's adding more punishment. It's punitive and creating greater punishment for the crime. And I mean, that might be a good baseline as far as looking at the arguments made in that case.
Well, now I have tried to move forward with talking to attorneys and going back to the original charge because there was no evidence, even though I subjected myself to all the tests to prove my innocence. The alleged victim refused all the medical exams. I was found guilty, and I've tried since '86 was when I was convicted, was when I was charged with this crime. Since '86, I have talked to several attorneys, and the first thing they tell me is because there's no DNA evidence that there's no way that I can go back into court to fight the original charge. But then to add insult to injury, in 2015, I missed a check-in. I was violated, and I just got out of prison 3 weeks ago.
Oh,
I spent a year, and I got sentenced to a year and a day because I missed a 15-minute check-in.
No, you were late.
I was late. Yeah, I was late. I actually called to find out if I had made my the registry because I own two businesses, and I was so busy with work that it just slipped my mind. I just got out of prison 2 weeks ago for being late. So I am outraged by how this has been. I got complacent. Since '86, I got complacent, but this was a rude awakening to me that this ain't over with. And so I'm looking for someone who will take my case, who will at least look at it and tell me if I have valid legal ramifications here that can turn this around. I mean, I've been living this hell for 32 years, and I want to make some changes now.
Yeah, I mean, as far as the underlying conviction, I think that the attorneys are probably right. I mean, there's not going to be a way for you to prove actual innocence without any sort of DNA, you know, pointing to the fact that it was somebody else. So, I mean, you could try contacting some innocence projects, but I think I don't see how that conviction could be be challenged without DNA evidence. And I mean, as far as the being penalized with a year plus in prison for missing a check-in, it's terrible. I mean, it arguably, in my opinion, is still an unusual punishment, a violation of the Eighth Amendment. I don't think that argument would go anywhere, because these are the penalties for, most people in almost every state. They face jail time or, extended registration periods, very severe penalties for not complying to a T with the duties and whatnot. But I can't think of a way for you to have any recourse with the time you just spent in prison for missing a check-in or being late.
So I'll expand on his comment, and we're trying to get rid of so much echo, so I'm muting people after I think they've got the question in, but we can fill in what we were talking about before the break. When he says an attorney won't take his case, I'll translate that. What he means is an attorney won't take his case without compensation. If he were to go in with a boatload of money and say that I want to make these challenges, I can assure you that there will be attorneys that will take his case. So even though there might not be a lot of merit there, I'd like to think that most attorneys are ethical, and they'll tell you that this is not going to likely be a good challenge. But if you want to pay me to do it, I'll give it my best shot. So that's unfortunate that we don't have in this country the necessary resources for people to seek redress, because oftentimes you're near indigent if you have to register because of lack of employability. So I'm going to ask a question that I think is directed to Illinois. I don't really have enough information, but maybe this will make sense. I don't know if the person's on supervision or not, so I don't know the context, but it came in electronically. Wants to know if he'll be allowed to visit his grandma in the nursing home in Illinois. Well, I don't know if he's under supervision, but is there any kind of nursing home prohibition that somebody should be advised about in Illinois? Or can they tell him that he can't come in a nursing home?
No, not that I know of. I mean, there are countless restrictions and statutes and whatnot that cover sex offenders here, and I don't know if he's a child sex offender or, what child sex offenders and sexual people classified as sexual predators, which is almost everybody on the registry in Illinois, face more restrictions than people who just have to register but aren't classified as one of those two things. But no, I mean, I think that he can go and visit the nursing home. It's just he would have to also make sure he doesn't violate one of the other laws that may apply to him if he's a child sex offender, whilst doing so, such as, loitering, being present in a school zone without permission, or loitering within 500 feet of a park. And so I don't see any problem with him going to the nursing home. I'm not aware of a law or a restriction that poses that limitation.
So, and of course, then we could build this out. Well, if he's under supervision, if he's in another state, there's a whole lot of things. But assuming he is in Illinois already and he wants to go to a nursing home, that would be the answer. But we really didn't have enough information to thoroughly address the question. So I'm going to take the next caller, area code 215. What's your question for Can They Do That? What are they doing?
Yes, hi. My question kind of has to do with one of the previous questions about social media, but it's a slightly different. My question was especially pertaining to Facebook, and I was curious what, if anything, was going on with Facebook, and they're not allowing any sex offenders on Facebook, and if there were any legal challenges to that, and especially in Pennsylvania, where I am.
That sounds like a Lea question.
I'm not aware of any lawsuits against Facebook out of Pennsylvania, but then again, I'm kind of limited to what I would see in the news or coming out on, that I've seen on Twitter. But as far as whether I think that that's going to be a potentially viable lawsuit, I think that it would be fairly difficult because one of the things is that Facebook is a bit of a private entity. So although you have, freedom of speech, that's a government right. But if Facebook is deciding that they want to exclude a particular group of people from their services, I don't know if there's really going to be too terribly much that someone would be able to do to force them to let them in, unless the classification of the services they offer would happen to change. I think that one thing that's slightly similar is how some people are attempting to sue Twitter for removing them from their particular venue. And, it's those attempts haven't been very successful to date, but I think that if there is going to be a path for people to try to follow, that would be it. But again, I think that when you're talking about a private company deciding that they want to restrict registered sex offenders from their particular product, I'm not certain that a suit of that nature is going to be terribly successful.
Lea, let's stop here for a second. Are you playing an audio in the background? Have you got a feed running? Because we're getting feedback, and we've isolated it down to you.
Yeah, I'm actually not. I'm on the headset.
And there's no audio feed going. There's no speaker or anything.
No speaker, no nothing. I'm in a completely quiet room. So, yeah, I'll go ahead and mute myself while I try to figure this out.
Andy, go ahead and chime in here, because this is making it very difficult for people to hear the thing twice. So, are we still thinking it's coming from this connection, and what can we do at this point? Mr. Producer, are you there?
I am.
Yeah. So I was thinking that we had isolated this down to that there was feedback coming for like a radio playing in the background, which she would be playing, and she says she doesn't have anything coming back. She's not playing anything in the background. We really need to try to figure out where the source of that is, because it's very discombobulating to have it coming through twice.
I understand. When she mutes herself, it goes away, and only when she is speaking, when she's unmuted, is the feedback coming back through.
So should we switch her to a telephone?
We can go that route.
Let's try that, Lea. Why don't you call in on the telephone? And my goodness, I don't know what her number was, but we can try to get you on the telephone, because this newfangled is apparently causing a problem, unless it's mine, and I don't hear it on myself at the moment. So let's try to get you on the telephone here. So you have her number, Andy, so you can spot her as soon as she calls in.
She can email it.
So
yeah, I do have her number. I do.
Okay. So all right. Well, then we're gonna go ahead and take the next call, and since we have a full panel here, so area code 860, you're on. So can they do that? What are they doing?
Yes, hello. I'm calling from Connecticut.
Go ahead.
Can you hear me? Okay. We have a little bit of a different situation in Connecticut, where we have mail-in registration. So everybody is on a quarterly basis, and you must mail in your response to state police, who send it out every 90 days to you. Which sounds easy, but therein lies the tale. All sorts of problems happen with mail response via the post office, and whether or not the state police receive it. To add to that, and the point of my question on can they do that is, apparently the state police, having been charged with this responsibility, have made up the procedure that you have 10 days for them to have a response in their hand.
User disconnected from your channel.
Their letter.
Go ahead.
Hello?
Yes, go ahead. We're hearing you.
Oh, I'm sorry. I got a message you've been disconnected. Okay. So you have 10 days from the date of their letter to have your response in their hand. And of course, the date of their letter is not necessarily, and almost never is, the date of their mailing of the letter to you. Issues have come up where they've dated their letter in a holiday week, and of course it's not mailed till 3 or 4 days later, and giving you a minimal response time. My question is, can they do that? Can they arbitrarily make such a small space that it causes all these problems with response time, which of course then they send out to your local police. They send you a violation letter on the 11th day, and they send it over to your local police to investigate the felony of not registering in time, not responding in time. That's my question.
That's an interesting question, because it generally, I would like for that to be the process, but if you get it to right at or past the deadline, so what's your take on that, Katherine?
I mean, I think it sounds like inherently problematic, almost unworkable, and like a huge mess, for a lot of the reasons the gentleman was listing. But I don't think that there's a constitutional issue with a statute that says, the police department mails out the registry forms, and you need to have them returned within 10 days of the date. I don't think, just on its face, that there's a constitutional challenge to that. I think that the legislator hasn't thought through all of the, the technical problems that this could arise to. I mean, I think that you run into problems of being able to prove whether you did mail when you received the letter from the police department, when you mailed yours back, et cetera, et cetera. If you were to have be prosecuted for this, I think that the state might have a hard time coming up with actual evidence, because things get lost in the mail all the time, and we know that. As far as just for your own safety precautions, I would just go physically take the form to the police department myself. You have to do it 4 times a year. I would just do that so that I was assured that I wasn't going to, possibly face prison time. Right? I don't know if Lea wants to add anything to that.
Would you demand a receipt from them if you go in person?
I probably would. Yeah.
Many of us have taken to sending our responses registered certified, and they get so many of them that they don't even date the receipts, the mail receipt, which requires a date. They just come back stamped, group stamped. It's such a problematic issue in this state. People respond, some people just put a stamp on it, but it also causes a... Go ahead, please.
I might not be thinking this through quickly enough right now to come up with a way to challenge it. There might be. I mean, because it does sound really problematic. It just sounds like, an accident waiting to happen, and that people won't be able to avoid, at some point in time, not complying with this just based on no fault of their own because of the mail system and whatnot when the police department mails it out. So I personally am not coming up with what the challenge would be, which is not to say that there isn't one, because it sounds like there should be. It seems like there should be. So I don't know if Leah's back on the line. She has more experience than I. I don't know if she's going to ask.
Right. I think that it's one of those things where it's jurisdiction specific, because in Pennsylvania, your duty to report is really not related at all to the notice that you get. Like, the statute specifically says that, hey, if if the notice is failing, then that's not really a defense. So, but again, we don't have the form. It's something where you actually have to show up in person to do the updating. And I don't have any experience outside of this particular jurisdiction, but I would think that if the police are responsible for giving you something that is needed in order for you to complete your obligation, I don't know if there's some route of doing some type of an administrative challenge, because again, in Pennsylvania, if there's a duty that the state has to help you, to basically help you fulfill one of the obligations that you have, and it's something that's absolutely necessary, I would think that some type of an administrative action or a suit to compel the administrative agency to do what they're supposed to be doing in a proper time period would be the way to go. But I'm limited by my experience, which is Pennsylvania.
So, well, I hope that's helpful. I can understand where he's coming from. So for those who have not asked a question yet, the queue has thinned out, so you can hit *6 and we'll get to you as quickly as we can. So area code 503, you're on Can They Do That? What are they doing?
Good evening. How you doing, sir?
Good. So what's going on?
Yeah. Okay, so I want to ask a question of the lady who was on Illinois. Are you a litigant inside of Illinois?
I think you're referring to me, but I didn't catch everything you said.
Are you a lawyer inside? Are you a lawyer inside of Illinois?
Yeah, I'm.
Good deal. So a good friend of mine who has my counselor on my case. I have a federal case going on right now with the lawsuit. Attempting to reverse my contract from the military. And what happened is that they were doing a wholesale factor.
Is anybody hearing him? I'm not able to follow the question.
I'm not.
I'm gonna apologize and ask you if you can either call in again or speak directly into your phone, because we're okay. Try one more time. Try one more time like that.
Can you hear me now?
Yeah, try just like that. Now? Yes, proceed just as you're speaking. Right now.
Okay, so my attorney is actually from Illinois. He used to be a JAG attorney. Well, the thing is, I'm dealing with a federal case right now where I was discharged from the military due to the fact of me having a sex offense nearly 10 years after the fact of my offense. I was allowed to stay in the military, carry a weapon, do everything I was supposed to do, get promoted as a soldier, and re-enlist, more than a few times. But it was discovered that I was a sex offender during the time that I was in the military, and they decided to discharge me in lieu of my retirement. No punishment, no nothing, and no due process. They just kicked me out of the military a handful of months short of my retirement. Now, what happened is that I was sent to the state where my conviction happened, and then eventually, after me being discharged, a handful of months after me being discharged, I was given the opportunity to show up to the court to relieve myself from registration in the state that I was in. I was relieved from registration immediately, which didn't take any time at all. With the course of 10 years, I ended up in the state, adjoining state next to it, and I had to register over again. Well, my concern is that I ended up having to register here in the state that I'm in now, and it's not indefinite, but they're giving me the opportunity to stay on registry for 5 years, and then at the point of the end of the 5 years of the clock ticking, I can submit to the court to be released from registration from the state that I'm in now. Now, the state that I'm in now, it's very fair to a point where they allow level ones not to be on the internet. Also, we are not complying with the SORNA regulations. So my concern is, if I try to travel with the IML status, am I allowed to travel if I decide to say I'm moving to the state where I was actually released from conviction, and then return to my state after the conviction, after the registration period was relieved, and I was able to get a passport without the stamp of the state that I moved to, which is the state where I was actually released from the registry.
I'm not entirely sure I'm following well enough.
Yeah, it was difficult. It was difficult because he told a story. So I think the question is, if he gets off, I believe he might be in Oregon right now. Is that correct? Are you in Oregon or Washington? Correct. You're in Oregon.
Correct, Oregon.
Yeah. So I think his question is, if he gets off in Oregon, then he's worried about if he travels, because his conviction's not in Oregon, but he's going to use their process to get removed. And can they continue to hound him, go somewhere? Is that your question, sir?
Well, my question is, so say for instance, theoretically, I moved to the state where I was released from my conviction, and I go to that state, and I'm not required to register there because. Okay,
but you're talking confusing here. The state where they're releasing you is Oregon. Is that the state of your conviction?
No, the state of my conviction is in another state. But
you're saying if I travel to the state where I'm released from my conviction, that's what's confusing us. What do you mean by that?
No. Say for instance, I changed my residence to the state of where I was convicted, where I'm no longer required to register, and then in turn go to that state for the time that I'm traveling, to get a passport, and then claim my residency back later on for Oregon. Am I still required to? Will there be a question with that, or a factor where they say, hey, you move, I move back to the state? I go to get a passport without because I'm no longer required to register in the state where I'm convicted, and I go get a passport there. But then later on in time, I return to the state, of Oregon, and decide to live there again. So I don't know what kind of formalities or things I have to suffer because of that.
So that's not exactly. Go ahead.
I think, okay, let me rephrase the question. So basically what you're saying is that, let's say that you're convicted in state A. You go back to state A and have them lift your registration requirements, but then you go to state B. Is your question whether you would have to comply with any registration requirements since state A lifted your original obligation?
Correct. And because the thing is, my intent is to get a passport when I don't have to have the stamp on it, because I'm going to the state where I was released from required to being registered. So the thing is, though, in order to get a passport without the sex offender status on it, I would have to be in a state where I'm not required to register. Am I correct?
Okay, and I don't know if that's going to be an accurate representation, because it's a part of it is going to be whatever the federal requirement for that is going to be. But the other issue is that, let's take Pennsylvania as an example. The way that Pennsylvania does it is that if you're convicted of an offense that's equivalent to a Pennsylvania offense, you have to register for however long the equivalent offense is in Pennsylvania, or however long your original state was, whichever is longer. So where you may end up getting tripped up is if you move to a jurisdiction like PA, if your offense is something that's a lifetime offense, under the equivalent Pennsylvania law, you're going to have to register here, even if that first state lifted your registration obligation.
So, well,
I think that
I've got the question. I think he's worried about getting a stamp-free passport, but that's a separate issue. If he can get off the registry and get a unstamped passport, if he goes to a state anywhere that his offense is covered, he would have to register again potentially, right?
Yes.
And then he could end up right back where he started from, because Oregon can only release him from their requirements. They cannot release him from any other state's obligations.
I think Leah's first point was really targeted to his question. It's not going to be the original state where the offense happened. Their laws about how long you have to register. So if you're off the registry, are you automatically going to be able to get a stamp-free passport? That state isn't. So their laws aren't going to be ones that control whether you get the stamp. It's going to be the federal laws, and I don't know what you know.
And our understanding is, and this is early in the process, our understanding is that the stamp will only apply to those who are actively registered, but that could be wrong, because this is a work in progress. So I would ask the caller. I'm going to move on. If you can get back in the queue again, if we have time. Be more specific about what state you were convicted in, what state you're petitioning to get off, where you're filing your petition, so that we can be clear on what we're trying to answer. But generally speaking, one state has no control over what another state requires, so they can release you all day long. And if you go to a state that describes defines a registrant to be a conviction like yours, you go to Alabama, it makes no difference what any other state says. Alabama says if you're alive and breathing and you have a sex offense conviction, they require you to register. So it matters not what Oregon or another state did. So we're going to go on to area code 772. You're on Can They Do That? What are they doing?
Hi, I am a mom, and my son is in a federal prison. He won't be out for another 11 years. I want to relocate. We are in a very restrictive state, in the state of Florida. And just hearing that fellow saying that he was 15 minutes late, it kind of scares me, because that's what we're running into here. I want to know if probation can stop me from relocating. If I relocate to another state, will they say that my son cannot live there?
That's a great question.
Not that I'm aware.
That's a great question. He's going to be on federal supervised release, I'm presuming, when he gets out.
For life.
I don't think that this is just an opinion. I don't know the answer for certain, but no, I don't think that your son would be barred from moving to the state that you moved to. He'd still have to fulfill the probation time wherever he is. That's an opinion. I'm not certain of that.
Okay, because there are minute differences. The driver's license isn't stamped. There's no scarlet letter that goes out to all of the neighbors as they would here. But those are things that can make your life more comfortable. They don't sound like big things, but those things are things that make you human. When 35 people in your neighborhood knows that you are a released registrant, and your driver's license, when you're asked to show it, is stamped across your face that you're a sex offender. Those kind of things can keep you from growing.
Oh, absolutely. They're dehumanizing. I completely agree. I mean,
so I have found interest in another state close by, but I was hoping that I would not run into a restriction where they would say, no, your son can't live here. If I follow the rules, if I know that I'm 1,000 feet from a park or school, same as here, same as home. And I've talked to the U.S. Marshals who will release him, and they're telling me they're going to release him in the state of Florida.
And the question is, can he do the probation time in a different state since it's a federal crime? I don't know. It's my opinion that he could, but I really, truly don't know well enough to give you an answer. Do you have any idea, Lea?
I know very little about it, and I thought that even with federal jurisdiction, I thought that there's still an approval process to have it transferred from one district to another. But the last time I read about that was probably back in 2009. So my recommendation would be to consult an attorney who does federal practice in your particular jurisdiction.
So caller, where is he serving? Where is he serving his time right now?
He's in South Carolina.
Okay, and
our home is.
And his conviction was in a federal district in Florida.
Florida, right? It was a computer crime. So
the jurisdiction of that case is there, and I do so little federal practice. Most of the work I do is state, but I do know that there is a process to transfer the jurisdiction. If it's a state conviction, it's a process, interstate compact for adult offender supervision, which I'm well versed in. But in the federal system, there is also a process to transfer. But you really should talk to a professional. And I don't even know that an attorney in Florida would be able to start. But what you're going to run against is if they move his supervised release to another jurisdiction, the attorney in Florida is not going to know exactly how that jurisdiction works. So if he goes to Maricopa County, Arizona, they may have the federal probation service there may have restrictions that they don't employ in Florida. So probation conditions can exceed what the laws is. So you do all the research in the world to see what the laws are. Even if you cover local ordinances, you may miss what the federal probation service is doing in the place where you want to transfer to. So you need to have a conversation with an attorney whose practices in a federal that is federally qualified and does this type of stuff to know where you want to go. And he or she can tell you that, well, actually, you don't want to buy the house there because it's not only 1,000 feet from the school, parks, and playgrounds, but it's all these other things as well. So you're treading in very dangerous waters. You could end up buying a house and you can live there, but he can't.
Yeah, but it can't be any worse than Florida.
Oh, believe me, it could. I've got a person here in Alabama would be glad to tell you that's a whole lot worse. But it is very bad in Florida. But yes, you need very good advice, and I don't think any of us are qualified to tell you other than that you're on eggshells in terms of what you do. You want to get out of Florida, and you could be in a situation where you buy a home and he's not allowed to live there because the probation service has restrictions that you did not know about.
Yeah. Okay, thank you for taking the call.
Thank you. So those of you who are wanting to get into the questions, you can hit *6. We've got some lines open, as I say on the radio. So you're on. Can they do that? What are they doing?
What I'm considering is, what about sex offender treatment after parole or probation? When the treatment provider is less than forthcoming, there's no transparency, and it ends up being aggressive and hostility from the provider to the folks that are there. And it just seems to me that it causes so much anxiety that it could lead to recidivism or to drug and alcohol use. How do we fix that?
Who wants to take
I
that
mean,
one?
I'll throw out an opinion. I don't have an answer, really, other than just, I mean, are you ordered to go to a specific treatment place? You know,
Yes.
where you're going. You have to. I don't know.
Yes. According to the state probation officer, he has one of three choices to send someone for treatment, and they're all on a weekly basis, and are able to call upon you to take a lie detector test.
Mm-hmm.
If you fail, you go right to jail.
So you've been assigned one person in particular, one treatment facility, and you're having issues with it, and he has the power to choose between three places. Have you tried all three? Have you asked for him? You discussed this with him and asked to be switched to one of the other two?
Well, it actually became two. One of the ones went out of business. So there's only actually two. And no, we haven't had that discussion yet about that. So I guess it's an ongoing issue that we have to deal with probation and parole department. Just a quick note. Can you give us in a nutshell the Muniz decision's importance?
I think Leah is better versed in that than I. I think you were mentioning it earlier. I would know.
Mm-hmm.
So the Muniz decision in general, or how it relates to the counseling requirement?
How it relates to, I guess it's the ex post facto decision with the increase of registration years.
Right. So with Commonwealth v. Muniz, what it basically said was that for individuals who had offenses that were before December 20th of 2012, the original term of registration that they had was increased. And along with, now that increase by itself was not necessarily problematic. The bigger issue was that the more onerous registration obligations. So before, people only had to come in once a year, but with SORNA, which came out in 2012, they had to report in person. For some individuals, they went from not having to register at all to having to go in 4 times a year. Some people who had to go in one time a year, that was increased to, again, 4 times a year. And then you had this more intrusive effect on the reputation by having the information available on the internet. So what the Supreme Court said basically is that all of these things go beyond just a civil measure, because the way that the U.S. Supreme Court and other courts have justified sex offender registries in the past was by saying that it's just a civil measure to keep the community safe. It's not so burdensome that it's like a punishment. What the Pennsylvania Supreme Court said was, look, in light of what all this does, especially with new technology and the internet, this is punishment. Making people come in and report, it seems a lot like probation. Having all of this public information, you know, it's like a scarlet letter. So since it's something that's punishment, they can't go back and change it for people whose offenses took place before the new law came into effect. So where Muniz is really important, I think that one thing is that, you know, it's helping people whose registration terms were increased without, you know, them having any type of true advance notice before being convicted. But I think the bigger thing is that the Pennsylvania Supreme Court came out and said that these measures are so burdensome, they are so onerous, that it's punishment. And I think that that's going along with what some other courts around the country have done as far as determining that when you're looking at these particular registration obligations, it's not just having a list of people and the charges that they were convicted of. It's actually something that's punishing them. It's like shaming, and it's very similar to probation. So I think that that's where the significance for Muniz nationwide is, that it is one more, it's basically one more case to sit here and say that this type of registration is just, it's punishment, and it's not closely enough related to public safety. You know, that particular leg of the argument, I don't think that it was fleshed out as much. I think that the major thing that the Supreme Court drilled down on was the fact that the measures are it's punishment. It's too onerous. So I think that that's where Muniz' real significance is that it's showing that it's punishment.
So thank you for that question. We're moving towards the top of the hour, and I don't know if anybody of the attorney team can stay on, but all of a sudden the queue filled up. So I'm going to ask people, please try to compress your question on this final stretch so that we can take everyone, hopefully. So area code 218, what are they doing?
Hi, my name is Sean. I'm in Minnesota. So when I was released from the Department of Corrections, I signed a standard conditions of release form. And on that, it states that I have to sign any waivers of information for medical and mental health treatment as required by my agent. What I'm running into is that our programs up here are funded by the Department of Corrections, and so it seems that they are requiring us to sign entire waivers where they get any information they want from our treatment provider or any other mental health. And I don't want to release all that information. I just want them to have the general that I'm participating and I'm in good standing. I've had this discussion and they told me that it would look like I was hiding something and that I might face a violation should they not get the information they want. So my question is are they violating my HIPAA rights by forcing me to sign an entire disclosure, or do I have the right to limit the scope of the information that I want released to the Department of Corrections from my treatment providers?
That is one of the best questions I've ever had, and I really wish that we could really we could do a program on this. So I really like that question. You've got the star for the best question so far today. I've raised this issue. I've raised this issue myself. How is it that treatment can be effective if anything you say, if you have to sign a blanket release, and they do this in the team containment model all over the country? What is the person's recourse here?
I don't have an answer off the top of my head, so I'll say that right now.
And I would say that my natural impulse in a situation like this is that anytime you see that there's a privacy interest that appears to have been intruded upon, I would go with the civil rights lawsuit to basically say that as far as making it as broad as it is, I would honestly want to have the agency that's making this policy explain why it is that exactly they think that they need that much information. Because of course they're going to have the argument that it's part of your rehabilitative interest for them to know what's going on as far as your treatment is concerned. But if it's something that's not necessarily related to the rehabilitation, I would think that such a broad release is just simply too broad. So I would try a lawsuit to try to raise an argument about how it's too intrusive and it goes into the privacy interest.
So find a practitioner. Find a practitioner in Minnesota that will talk to you.
Yeah, the problem we're running into with this is that by signing that entire waiver of release, we go into treatment and we're not able to be honest, talk about things that are going on. It's not treatment. It becomes the Department of Corrections checking up on us in another way. And so the problem is that nobody feels comfortable saying it. And so they just kind of keep their mouth shut and nobody's really doing anything.
It diminishes the value of treatment.
We just want to know if it does. And then at the same time, it becomes another way for parole to check up on you. And they use that information to violate you or restructure your parole based on treatment recollection of what's said in your group therapy.
So it's terrible. You may have a viable cause of action. It's one dear to my heart. I may call you after this program.
Absolutely, I'd be open to speaking.
So thanks. Area code 215. You're on live. What are they doing?
Yes, hi. I had a Pennsylvania question. With the section in Act 10 about the 3-year probation, wouldn't that basically make this new sex offender law a punishment?
I don't think that invalidates all of Act 10. I think that there are certain constitutional issues as far as this particular provision in itself. There was a case it's the Aline case. I could go on for a very long time explaining that case, but basically what it says is that any type of measure that increases your punishment. It's something that has to be submitted to a jury, found beyond a reasonable doubt. The person has to be given notice. So I think that this particular measure, I think that it runs afoul of the lien in at least 3 different ways, along with some other constitutional problems that it has. So does it call the whole of Act 10 into question? No, but I think this particular measure itself, I think that it's a constitutional issue for direct appeal right off the bat.
Okay, thank you.
So, area code 51541, I believe this is Iowa or Washington. I lose my area codes, there's so many of them, but you're on. What are they doing?
This is Shelley in Oregon, actually. It's Eastern Oregon. Anyway, I don't know if anybody over there can answer this question, but we have a person in our Oregon Voices group who finished his 3 years post-prison and went every week to the treatment classes and paid his money to the tune of, over the course of 3 years, that was $7,000. And then he got a letter that he successfully completed his probation. He was released, and then got a letter later from the treatment provider saying he never did finish his treatment, so he doesn't have a certificate. I don't know if there's any kind of legal recourse or if anybody even knows who to contact in that kind of situation. Because now Oregon's they're classifying everyone, and we're going to a tier system soon, and by 2020 this should be completed. And that will probably come into play for this individual, that he does not have a certificate. And to further elaborate a little bit more, he checked into getting one. He went to a recommended provider and to start again, and he said he'd need $1,800 for a new psychosexual and then a new, have to pass a full disclosure again before he could even start. And then it would be $186 a week for classes. So it kind of tied his hands. I don't know. I'm just wondering if there's any kind of recourse that anybody knows of in that kind of situation. It's kind of big, I know.
Okay, so is it that his probation supervision is not going to end until he gets that certification?
No, it's that he seems to be running into issues with people are concerned here in Oregon that might be a red flag when they go to reclass, because this person right now, like a individual prior said, in Oregon right now you're either not on the list or you're on the list because you're predatory. So it's basically kind of a 1 in 3 situation now, but we're going to a tiered system, and concerned that not having that certificate might bump him up a level, I guess is what the concern was. Not really sure. But
okay. And I think that with those particular facts, it kind of sounds like it's going to depend on how the law is going to end up changing. And, what his current status is as far as, probation, parole, et cetera. It sounds like you said that his supervision is complete. But either way, what I would want to look for is an attorney in the area that deals with probation issues, but also is well versed in sex offender registration issues.
Okay.
So
I will pass that on.
He's trying to prove that he had the treatment. And that's the whole issue here, because it may help him in his level registration. Do I have that right, Shelley?
You do, yes. Thanks, Larry.
Yeah. So he's done their kabuki show, but he doesn't have proof of certificate of completion. So he's trying to get that rather than having to go do it all over again, so that he will benefit from the level system they're implementing in Oregon.
Right. And in my experience, attorneys that have a lot of experience dealing with probation violations and parole issues, they tend to know how to get that type of verification. So they know how to work the system and get that certification, or figure out a way to get a replacement.
Okay.
So and I'm working on a case out of Oregon here that we've hooked up with a firm for a person that's serving supervision in New Mexico. So we could possibly pass that name on. It's not a pro bono relationship, but it would be better than paying all those thousands of dollars to go through treatment again. So you can feel free to contact me. You're one of our advocates, so you know how to get a hold of me. So be happy to try to help if I can. So thank you. Area code 217. You're on live. What are they doing?
Yeah.
Yes, I have a couple of things to mention here on the treatment thing and on the other question about the poor fellow who was wondering if he had problems moving to another state that would allow him to do that. And I was that was my situation. I just picked up my charge in Florida, and I was
we're in lightning round. I'm going to silence him for a minute. We're in lightning round, and we really need a question. Can you confine your comments and just get straight to a question, because we're trying to get to everybody's in the queue. So I'm going to reestablish the hookup.
Okay. What happens when we have to? If you ride a motorcycle in my state, in Illinois, they make you go in every single year and register. And not only have to register as far as your driver's license goes, I mean, you have to take a complete test and everything else. The problem with it is that if you ride a motorcycle, they have a little area that you go to the DMV, and if you have a big bike, it's almost impossible to pass that test because it's such a tiny little space. If you put your foot down, they automatically clear you. You know what I mean? And we're talking about a motorcycle that weighs 500 pounds, you know? And I'm an old man, but I've ridden them for 40 years. And I have to do this every single year. And what I'm forced to do because of that is the University of Illinois offers a course that's still aligned with the government. And you have to take their course. It's like 20 hours. And the only place it's given is like I've got to drive 7.
So I'm going to move on to the next question you're on, and please get back in the queue and give us a question. We'll come right back to you. So Eric on 520, you're on. Please state a quick question.
Okay, yes. My name is Sherry. I have a house up in Phoenix. My son lives there. He is a registered citizen. He has roommates, and probation has been asking if whoever comes to visit the roommates, that they need to have their friends cleared and make sure they have to give a license and clearance. So he can't have any of his roommates have friends just stop by. Is that allowed? I mean, is that impinging on their rights?
My gut reaction is that, yeah, that is probably allowed. I mean, probation officers have so much leeway to do essentially almost anything they want, including monitoring who the probationer is around. So it's an unfortunate situation that your son's roommates are going to face restrictions,
right?
By living with him, but I do think the probation officer is probably within his or her authority to,
they can't search him though.
No, they can't. They can search the rooms of the roommate.
Yeah, they can't do that.
I think that would be problematic. Shared household. I mean, I do not believe that they would be able. I think that the roommates would then have kind of a Fourth Amendment issue if the probation officers came and searched the rooms of the roommates without a warrant. But I don't know all of the details about the living situation, and if it's just like if it's your son's house and
it's my house and they're all renting.
I don't think that I know well enough to know whether. I mean, if it's yours and he's the one that's really in charge of it, I don't know whether they, without like a formal lease, if they could in fact actually go into the roommate's room.
Okay, and then also real quickly, can they ban people? Like my son is going back to school and working and all that. Can they tell him I know it was a computer crime, but it seems like everything is either on the computer anymore, everything's on the smartphone. I mean, he can't use any of that. And it almost seems like that's just a tool to get along.
He's completely banned from the internet entirely.
Right now. Yeah, he's allowed, when he's at work, he could use, because he's a waiter, he could use the register, and then at school he can use it, but that still puts him at a huge disadvantage.
I mean, he's not. There is a case that says probationers cannot be totally and completely banned from the internet. So, I mean, if he is able to get his schoolwork done technically. I mean, they would probably argue, well, he can use it at school and do research there on the campus, whatnot, and he does it for work purposes. They do have the ability to place restrictions on his internet usage and to monitor it. So since he has some, and it sounds like the things that they're going to think he needs it most for, I don't know that he has some sort of challenge there.
Okay.
So I'd like to add one more thing that when you say that a person, it's dicey because the person could assert their right that's not on parole or any type of supervision, say you're not going to come in my room, and can't probation just turn around and say, okay, you win. He can't live here because we need to have full access to make sure there's not contraband and inappropriate things taking place in the immediate vicinity of this offender. So what would preclude them from just simply saying, you're right, we can't search anything other than him, but guess what? This place is no longer appropriate. Would there be anything that would stop them from doing that?
I think if they all have locked rooms, keys and stuff that he doesn't have, I mean, I would think that would be something that they shouldn't be able to do, that would still respect their privacy. I don't know.
So the attorneys have any further comment? Because I tell people, they can't require you to get rid of your gun. You have absolutely a right to possess the gun because you're not convicted. But they can tell you that we will not allow him to live in a residence that has firearms on the premises because we're bringing our personnel in here and we do not want any firearms in the vicinity. So he can't live here. But yes, you can have your gun. Right. So I'm going to try. I think I found the caller that was going to try the question and see if we give him one more shot.
Yeah, it's working fine. That's true.
So did you want to try to frame up a quick question here? No story, a quick question.
Hello.
Yeah. Do you want to try to ask yes? Do you have a question?
Yes, I do. I was asking about is it legal for them to force people to pay extra fees every year on the licensing thing in our state is you get up to the age of 87, you got 4 years. When you get your license, it's good for 4 years. For a sex offender, you have to go in every year and take the whole schmear again and pay all the money on it.
Well, so the question is, I'm going to mute him because there's a lot of feedback. So would there be a viable, or at least a reasonably, I don't know how viable, but if you have to relicense yourself every year and reincur that fee, would that be enough to go forward with a challenge that the cost of a license is relatively benign, but if you have to do it every year, does that constitute a punishment that would be something to consider challenging?
Illinois does require sex offenders to renew their license every year, and I've seen it challenged along with like numerous other provisions in appellate court cases here in Illinois, and it typically just goes down with the rest of them, and the court says no, the registry is civil, it's not punitive, it's not an ex post facto violation. However, there was a recent third district appellate opinion that found the requiring a juvenile to register for a certain length of time, they found that to be too severe of a penalty for him. And when they made that holding, they included this, needing to register the license every year as part of their opinion, saying that was, in addition to all of these other things, the registration is punishment and it's severe. And so they did call it punishment in that particular case. I've not seen them do it before. But that specific provision that he's referring to is repeatedly challenged with all of the other ones. Anytime the appellate defender's office tries to tackle SORA, which they do anytime a sex offense conviction comes in on appeal. I don't think that there's it makes for a very provocative civil suit. And I do know that and Scott Morgan has posted it links to the bills that were going to be introduced in Illinois, and one was a proposal that this annual renewal not occur anymore, and that I think that it be changed to a 2-year renewal. But I don't think the bill is going forward. So it is on the mind of some legislators. It's probably not that helpful of information, but that's all I know on the topic.
So it would possibly be a factor that would play into a decision at some point if you added that to the showing the punitive effect when you do the intent effects analysis. You could throw that in, but a challenge standing alone doesn't sound like it's going to go very far, or hasn't gone very far.
Yeah.
So well, we're past the end of the program, and we have cleared the queue. So do either of our guests have anything that they would like to add? I think we had a lot of fun. We took a lot of questions. So we will get better at this as we go along. This is of a format. I don't believe we'll do it monthly because it's just too much work to put all these conference calls together, but we'll probably do it regularly. Maybe every couple of 3 months we'll do a Can They Do That as a part of our regular programs. But I really appreciate you giving me your 2 hours of time plus a little bit of prep to get this ready. And we'll get better on the technical side because we're looking for improvement, trying to get more distribution and trying to do it without cost. So we're using free platforms. We're not using something we're spending a lot of money on from our donors. So hopefully you forgive us. We will continue to improve as we go along. So is any other comments from Lea or Katherine? I look forward to having you back.
No, thank you for having me, and it was fun, relatively speaking. And thanks for putting it on, Larry. I'd love to come back.
Well, you're gonna be a regular until I wear you out. I tell people that are old enough to remember What's My Line. They had a program where that there was regular panels and alternating panels, and I would love to have both of you as regulars because it's a lot of fun having both of you on, and so I would hope that. And you're going to be at our conference, and Katherine, I would really hope that you make it up to Cleveland as well in June. So we would be delighted.
I am coming, Larry. I'm planning on being there. I've heard that it's in Independence, Ohio, and Cleveland, Ohio, and perhaps they're very close to one another.
They are.
But it is in
they
Cleveland.
are. Yeah, it's Independence is technically it's kind of like when you're in Vegas. You're actually not in Vegas. I forget the name of that place you're in, but it has a Vegas address. But so yes, you'll fly into Cleveland, and the shuttle will pick you up if you fly. And I think Leah's close enough that she'll probably drive. So
I'm actually planning to drive too.
Oh, you're going to drive? So,
but I will.
Well,
I'm going to drive. Yeah.
Yeah. Well, we will find a place for you somewhere to help put on this conference, and we look forward to having you. And I'll be putting on another NARSOL in action sometime during the month of March. So who knows? I may knock at your door again. But I really appreciate you guys.